to our little seminar workshop on the new Minnesota law for the sick leave that applies for anybody that has payroll, basically. So hopefully here we'll be able to answer all sorts of wonderful questions. This is myself, Susie. I'm the owner of Carefree Bookkeeping. I'm here hosting the event, and I have invited Colin. And I don't want to mispronounce your last name, Colin, so you can say it when you introduce yourself. He is a lawyer with Ogletree, and he specializes in employment law. So he's fully understands this law to the intent that he understands it. So, and then Erica, she owns Elevate Consulting, and she is an HR specialist, meaning human resources. She helps you with all of your wonderful employee frustrations, to put it that way. So both these people can help you update your employee manual or create one if you don't have one. So these are two great resources for you to go ahead and reach out to, and you'll see why I invited them both to come here and speak. So Colin, if you want to take it away from here, this kind of explains what's going on.
Sure. Well, thank you, Susie. As Susie mentioned, my name's Colin Hargreaves. I'm an attorney at Ogletree Deakins, and we indeed represent employers and know about these laws and specialize in labor and employment matters. So, and I'm one of the local experts in the Earned Sick and Safe Time law. I've actually been following the law since it was a little bill. If you remember the Schoolhouse Rock song, that was me tracking this bill throughout the legislative process and then subsequently to its passage. So I've been deeply involved in it, and deeply involved in also the gaps and the nuances and confusions it brings. So happy to chat about it today. Now, I see we have a smaller group today. So, to the extent you have any questions, feel free to chime on in. This can be somewhat interactive given the amount of folks we have on. So please feel free to interrupt and say, hey, I got a question. I can't guarantee I can answer all of them. I can speak about the law, but unfortunately, I cannot advise you specifically on what you should or should not do. So that said, let's get into it. So as the slide up here indicates, the law goes into effect here really soon, January 1. So that's about 2.5 weeks away. We're getting close, but you still have time to get into compliance with the law if you aren't already. It's critical to connect with your lawyer or Erica or whomever to ensure you have the relevant procedures and notices and revisions to your handbook in place to ensure you're ready to rock starting January 1. So Susie, why don't we go to the next slide, please? All right, so a lot of folks have been asking me, well, what is this law? What is Earned Sick and Safe Time? Some folks know it from the local ordinances that were passed previously, namely the Minneapolis, St. Paul, Bloomington, and Duluth ordinances. But now it's a statewide law. So employers are going to have to comply with both the state law as well as the local ordinances, which we'll get into here in a second. So there's a definition up there, but I'll expand upon it. But Earned Sick and Safe Time means paid leave that is paid at the same hourly rate as an employee earns from employment that may be used for the same purpose under the same conditions, but in no case shall this hourly rate be less than the provided under minimum wage. So in effect, employees are allowed to use Earned Sick and Safe Time upon the occurrence of a number of events and qualifying conditions. The law also has, and we'll get into those conditions in a second. I'm not going to purposefully leave you hanging or anything. The law also has job protection. So for those of you who track FMLA, or if FMLA is applicable to you, which if you're smaller employer with under 50 folks, then you likely don't deal with FMLA all that much. But if you do, then you should be familiar with this requirement. So, but in effect, you can't just terminate somebody upon returning from their ESST leave. Their job is protected, so to speak. So let's go to the next slide here. And Erica, to the extent you want to chime in, please feel free to do so. We don't need me just babbling on for hours today, because Lord knows I could do so. All right, so as I mentioned, the law provides this leave to employees. So it's different than, minorly different than some of the local ordinances which you may be familiar with. Some of the ordinances are now starting to comply with the law. For example, St. Paul and Bloomington recently said we're going to comply with the law and changed a number of aspects of their ordinance. However, it's not a 100%. It's not 100% similar to the statewide law. So there's a few little minor differences, mainly in definitions. So to the extent you are in St. Paul, Minneapolis, or any of the other jurisdictions with these ESST ordinances, connect with your attorney about them, because it can get a little dicey on, well, what does this mean compared to this? How do we reconcile these two definitions in this law? So the law in general applies to all employees. Doesn't apply to independent contractors, but it applies to part-time employees, full-time employees, exempt, non-exempt, seasonal, temporary. As long as they're an employee for you and getting W-2 wages, they will accrue or be entitled to front-loaded ESST time. That's different than a lot of laws. So this is very broad and applies to a number of individuals. However, the qualification to that is the employee must work at least 80 hours in a year. It gets even more confusing when they start accruing the first hour they work in Minnesota. So they'll start accruing, but they can't use until they hit that 80-hour mark. But like I mentioned, this doesn't include independent contractors, and there's some other exempt individuals as set forth in the slides. And as I mentioned, this includes exempt, non-exempt, any employees. The one qualification of that is for non-exempt. Of course, those employees are working on an hourly basis, and so we can track them and how many hours they're working. That's a little different for exempt or salaried employees, who the law presumes works at least 40 hours. Now, that presumption can be overturned with evidence that they're either working more or less, but generally speaking, it's 40 hours. And then, as Susie mentioned, an employer is defined as any person who has one or more employees. So effectively everybody. All right, so next up. So employees are, you have employees in Minnesota. So there's a couple different methods that these employees are going to get their paid ESST hours. And this is different in a lot of respects from the ordinances. So you can choose any one of them, but you must comply with at least one. So the first is accrual. Accrual is kind of the basic one. It means an employee is accruing 1 hour of ESST time for every 30 hours worked. Now that goes up to a maximum of 48 hours. So for example, a first year employee with you, they can accrue up to 48, and that's all they can have. And employees exempt from overtime are deemed to work 40 hours in a work week, as we just went over a second ago. And accrual begins when they start work. And of course, in Minnesota, if they start working in Minnesota. But like I said, they're only entitled to leave once they hit that 80-hour mark. So they will start accruing leave. And Susie, you want to go on to the next one? Well, I'll finish that thought on accrual. So employees can accrue up to 48 for first year employees, or if they are second year employees, there's also the carryover requirement, which is the first bullet up here, which means an employee can, any accrued but unused hours can be carried over to the subsequent year. So, for example, that first year employee works and accrues 48 hours, and then they go into the next year, and now they're a second year employee. So, if they don't use any of those 48 hours that they carried over, they'll start accruing another 48, and then they can accrue as many hours up to that 80 mark. Once they hit that 80 mark, everything stops until they use some hours, and then they'll begin accruing again.
So a couple things to think about from my perspective in HR related to this is around part-time individuals. I work with a company that has retail space or part-time individuals. And so I ended up having to sit down with the CFO because he was starting to do planning for 2024, looking at his budget. And I jokingly walked into his office and said, "Hey, I have something to add to your 2024 budget." And he's like, "Wait a minute. What?" A lot of people, to Colin's point, a lot of people kind of look at this, and I even go to Colin and his team and other legal professionals when we're writing it up. I think a big piece of this is actually interpreting it, right? And being able to bring it down into the employment area, bring it down into managers being able to train on it or understand it enough to be able to adhere to what Colin's even talking about, right? A lot of things we put into the handbook and then we don't actually understand what we put into the handbook. We've had a couple of conversations like that here at the end of this year as I'm going through handbooks and kind of acknowledging and looking at this stuff, and even some past stuff that I'm like, "Do you guys even do this?" And they're like, "No." And I'm like, "Then get it out of your handbook." So there's that piece of the handbook side of things, but also, this is something that's a huge piece of HR, but it's a huge piece of the business because a lot of people don't take into account the financial side. So again, I went into the CFO and talked with him a little bit about the number of part-time employees we have, what that could look like on average, what are they working, and how many hours are we going to have to look at potentially paying them out or allowing them to use, not pay them out, excuse me, but allow them to use. And then we had to get into the conversation of what PTO time and sick and safe time do we pay out as a company, which is, I know, a topic that Colin's going to talk about a little bit more, but those are all things to take into account outside of just, are we following the policy, but what implications to the business is there in additional to what we're doing? The other piece, to Colin's point, a few slides back, was talking about time cards, right? It's easy for hourly, but we also have to take into account that managers need to understand how it's being tracked and how it's being awarded so that they can talk through that with people. So I just wanted to talk about that. I do have a question in the chat. The question is, how does this work if the company is in Minnesota, but you have remote working employees in another state, or vice versa? You have Minnesota employees, but your business is located in another state. So can you speak to that a little bit, Colin?
Of course. I actually printed off some of the FAQs which directly touch on this, and I will share with you. If you'll bear with me for one moment. So the FAQs were published by the Minnesota Department of Labor and Industry, just to give you a brief preface on this, to help interpret the law. There's a lot of gaps. There's a lot of issues with the law, admittedly. So the department is tasked with interpreting it and then issuing guidance so myself and employers are able to comply with it successfully. So one of the FAQs states, does an employee have to live in Minnesota to be covered by ESST? And employees do not have to live in Minnesota to be eligible for accrual, but as long as those two requirements we just mentioned are met, then they will accrue leave. So For example, this happens in like Duluth and Superior, for example. They're two really close cities, and a lot of the times there's employees traveling back and forth to work with employers. So if you have a Wisconsin employee who's working in Minnesota and let's say they work there most of the year, well, they're going to hit that 80-hour mark. And if their employer's based in Minnesota, although the employer doesn't have to be based in Minnesota, which I'll get to in a second, they will start accruing ESST hours under this new law. So that leads me into the second piece of this is, well, what if we don't have a location in Minnesota, but we have employees in Minnesota? Well, those employees, again, are going to start accruing ESST hours as soon as they meet the 80-hour requirement, even if remote employees. So if you have a remote employee who is working, yeah, they're going to start accruing ESST, unless they fall into one of the very limited exemptions, like an independent contractor or something of that nature. So we discussed how employees generally accrue leave. So that can be a compliance challenge for a lot of employers. Especially if you have multiple employees who are going back and forth, and you have to track all this and make sure you know what time they have accrued, what time they've used, so on and so forth. And so the other alternative method is what is called front loading. Now, front loading is when an employer, based upon their year, front loads, gives the employee these hours that meet the minimum requirements at the beginning of the year. And year can be defined to mean various things: a fiscal year, an employment year, a calendar year. So it really depends upon your business. So the two ways that employers may front load, which are new now, is number one, an employer can front load 48 hours, but any of those 48 hours that are left over at the end of the year must be paid out. And that's particularly important for employers who they can't have an employee who's using 80 hours. Maybe it's a smaller business, and providing 80 hours to their employees is a hardship. So this reduces that, but then allows employees to get the pay at the end of the year. The alternative to that is an employer can provide or front load employees 80 hours with no payout at the end of the year. Okay, let's move on to the second one, or the next slide, Susie.
One question related to that, or comment related to that, is a lot of individuals are combining this with their PTO or their vacation policy. So, Colin, correct me if I'm wrong, but you also, if you're going to lump them together, it then really requires you to take a look at your handbook and understand what your company has chosen as a payout, because if it's lumped in with that, there's still, if we're saying we're going to, like, I have a client that says you can roll over as much as you want, but upon exiting our company, we will pay you up to 80 hours. At that point, because we're combining them all together, 80 hours gets paid out either way. Correct, Colin?
Yeah, so a couple points. So
Okay.
nothing in the law requires a payout.
Yes.
So if an employee separates, nothing says, hey, you got to give me my money. It's a matter of contract. So that means if it's in your handbook and you say, hey, I'll pay it out, which a lot of employers do for the benefit of their employees, unless it's that situation, nothing requires us to pay out. Just pay out at the end of the year for employees who have unused amount of those 48 front-loaded hours. To the handbook piece of this, yes, the law says it doesn't care what you call it or how you try to comply, even if it's multiple policies. We just have to have some policy that at least meets the bare minimum requirements of the new ESST law. So moving into, I mentioned ESST qualifying reasons previously. So there's actually a number of them, and I'll run through them briefly, but they can be found in the slide materials, which I'm sure Susie has provided to you all, or will provide to you all, or maybe not, but they're up there. And so they cover a lot of different aspects. So as the law says, it's for sick and safe. So sick covers, yourself, the family members, medical condition, mental health condition, preventative treatment, a number of different aspects of medical care. In addition, it covers, if you want to move on to the next slide,
No.
you want us to move back?
Yes. You hear me?
And so,
Thank you.
of course, so there's actually 6 different reasons. So the 3 that cover the preventative and medical aspects for an employee or employee's family member. There's also the different reasons that cover for the safe piece of this. So those have actually been broadened by this new law from what they were previously under the local ordinances. So the safe covers like seeking a protective order for domestic violence or a sexual assault or stalking. It can include a closure of an employer's business due to weather conditions or a public health emergency, or an employee's need to care for a family member whose school or place of care has been closed due to weather or the public emergency. It can be used because of the employee's inability to work or telework because of some sort of communicable disease. So really that's probably referencing not COVID specifically, but is included because of COVID.
So, Colin, you're saying if they work from home, but their internet went out, they could take a sick day.
I wouldn't necessarily say that. It has to fall into one of these conditions. And
Okay.
so it would be the inability to work or telework because of their medical.
Medical.
Yeah, and
Okay.
I think it may be on your next slide here.
Okay.
Or
Here we go.
maybe,
Yep, telework.
yeah, so there's a whole host of reasons that this can cover now, which admittedly is particularly harsh for employers, that now employees can miss work for, general sick reasons. The safe reasons make sense, but some of those are even pretty broad. And even the medical and the documentation required for those is even makes it even more arduous for employers. And we'll get at this in a second, but I'll just expand upon this. So an employer is allowed to ask for documentation for ESST. However, you may only do so when there's been 3 consecutive absences. So that makes it difficult when an employee just misses 1 or 2 days. And even if they do miss 3 and we ask for medical documentation concerning their 3 consecutive absences missed, even that medical documentation gives the employee the right to just issue effectively a written statement. So I tell all employers, exercise a lot of caution here. And anytime an employee is, calling in or we don't know why they're taking leave or we want to request documentation, please connect with your attorney to ensure you're doing it appropriately. Again, given that this law hasn't even went into effect and it's brand new, we're not entirely sure how the department is going to enforce it. So we want to be extra cautious, at least initially. That said, another quick qualification. So the department has mentioned that while they're not, at least initially, looking to kick down any doors and start looking to enforcement, rather what they're looking to do is look to compliance. But that still means we must try to comply, make sure our handbook is compliant, our policies and our procedures are compliant.
And to that note, I think there's something to be said for tracking in whatever tool. I know we're going to talk a little bit about tools, but making sure you understand, again, you don't have to go out and get every detail, but they're gone for a sick and safe leave reason. It needs to be documented in their PTO, when they use it as that, because I could see later on them coming back and doing kind of an audit. That they have the right, the government kind of has the right to come in and say like, hey, we want to know how employees are using these things with just cause, at least. And so it is important to make sure that not everything, even if you combine it with your PTO, you still maybe have separate allocations when someone takes it, so you understand how many of their days, if you give them 80 days of PTO and sick and safe, how many of those days are being used for sick and safe, and how many of those days are being used for PTO and vacation and things like that, just so that there's some tracking purposes as well.
All right, let's go to the next one, Susie. Okay. So, you may be wondering, well, if employees have this, broad number of new rights now, well, what happens when I'm a small business that relies on these employees and they just start taking time off? Well, thankfully there are notice provisions where employers are allowed to require notice. This would be something that you'd have to tell employees. And so generally what the law says is that if the need for leave is foreseeable, so like a preventative doctor's appointment, like a physical, you schedule that months in advance, and the employee usually has notice that it's coming up. So if foreseeable, employers may require notice of not more than 7 days advance notice. So you can do 1, 2, 3, whatever, all the way up to 7, but no more than that. If, however, the need for leave is unforeseeable, so let's say you wake up and you're terribly ill and you need to go to a doctor. Well, you didn't know that, earlier that was that morning. So then in that case, when the need for leave is unforeseeable, then employers may require notice as soon as reasonably practicable. Now, you're all wondering, well, what the heck does that mean? And we don't know yet. But generally speaking, I would just, what we've been seeing in handbooks is that language verbatim. And we haven't received any guidance yet that really defines what exactly as soon as reasonably practicable means. In any event, look at it on a case-by-case basis. Somebody's, of course, has been sick all week and maybe they were scheduled off, and then they're scheduled for a shift and they say, hey, I'm sick. Well, maybe that's questionable whether that's as soon as reasonably practicable, but exercise a lot of caution, like I mentioned. In addition, if you have notice, that notice must be a written policy, as I just referenced a second ago. So when you're including a ESST policy in your handbook, this is where you'd expand upon the notice requirements.
Where I see a lot of this coming in as foreseeable, oh, yep, I know I need to go take care of my parent or something because the surgery is scheduled, so I need to take time off. Unforeseeable, and as soon as, does your policy have a no show, no job in there? You don't report for work, do you get fired right away? So it still depends on your language in your handbook too, of how much time are you going to give them to report that they're not able to make it in for the day. And that depends on the industry too. Erica, any notes on that? Okay. All right. So as both Colin and Erica noticed or mentioned before, the record keeping of the sick and vacation time, your payroll software will have this available. You just have to turn it on or talk to your payroll rep or software rep. It does have vacation and sick recording separately, and that's what we want to keep doing going forward. A lot of small businesses don't even give out vacation time because they just can't afford it, or, oh, okay, you're going to take a couple hours off and it's an hourly employee. That's no skin off of the employers. But now going to have that 80 hours of sick leave that they can take for mental stability too coming out. So we want to record that under the sick leave to keep track of that. And then this is how it will show up on their pay stub, where they're going to see what's accrued. So if it's front end loaded, that amount will be here right away. But if they can't use it for 80 hours, I probably wouldn't front end load it until they've used up that 80 hours. That's where it gets into individually, how are you going to do that? To me, that just kind of makes it a little more work because you have to also track that they qualify for it yet. But after the second year, it's not so bad. So, and it's just, that's what they'll see this every time they look at their paycheck, what's available. So if they're not feeling well, they know they have time available type thing. So that's where you look at your procedures too. What are we going to do if somebody doesn't show up? Who's going to filter in? And that's something Erica can help with too, is those procedures going in and how do you handle this? Alex is asking, well, hang on.
I can ask it. So he was asking if there's any difference between salaried versus hourly employees for this. And the answer is no. An employee is an employee is an employee. And so they're all going to get whatever your policy is, which is what the sick and safe leave is. So it will be the same for all. I know we'll talk a little bit more about it, but if your PTO policy or vacation policy is more generous than what the sick and safe leave basic policy is, then basically you just, I'm going to very much simplify this and Colin is going to be mad. You basically just have to stick this inside your PTO policy, but there's more to it than that. But that's my shortened HR version of that. But there are some more, like making sure that all the pieces are in there, and how it can be used is in there. One other question that Alex had, and so Colin, maybe you can help with this one. He has different pay rates for different employees within his organization. It sounds like some are commission based and then others are paid hourly. So the work is a little at different hourly rates and stuff like that. How does it work if someone's commissioned and they're based off of commission? What does that look like? You're commuted, I believe.
Yeah, so that's a good question. There is guidance right now on commissioned versus others. Well, not directly versus others. So for regular employees, look at their wage theft notice, look at their offer letter to see what's the rate listed in there, or their most recent rate. That's what we're going to be using. So if you have an hourly employee who's just paid straight hourly, that's what's going to be the rate when calculating this. For commissioned employees, it really depends upon the type of commission, the type of commission arrangement. It will look into all that to determine an hourly rate. So it gets a little more complex with commissioned folks, unfortunately.
Which would handle a lot of people in the real estate industry for that have, salespeople.
Mm-hmm.
Yeah, and generally what the department is looking for is that they're getting, the employees getting something, they're not losing any sort of pay or anything. Which I understand with commissioned, it gets really complex. You know, I've helped employers with commissioned. I've helped employers who have employees who operate on a revenue generated model. I also helped employers who have highly compensated physicians. And it's always a question about, well, how the heck do we compensate these folks? So again, it really depends upon the type of commission, type of business, and type of commissioned arrangement you have with this individual. So I'd look at all three of those, or contact me, contact your labor and employment attorney, and have those documents ready, because you'll have to really look into those in order to have a good answer on that.
Okay. We just popped up with another question. What if the employees are paid different hourly rates depending on their jobs?
Yeah, and that's
Which,
totally fine. That's most of the workforce. It depends on that specific employee's hourly rate. It's not just one broad, well, I'm going to give everybody 25 an hour for using ESST. No, it goes by the specific employee's rate.
okay, no, but the one employee, if they're doing office work, they're getting paid $20 an hour. If they're doing cleaning, they get paid 18. If so, but they do those three different things during the day or the week that they're out sick.
Yeah, that gets even more complex. So, number one, again, look at the employee's offer letter, wage theft notice to see what's listed on there. If multiple and that's broken down specifically, then that's likely going to depend upon a calculation of what that employee traditionally earns per week. There's some guidance that the department has provided. It's not all that great because the department has been dragging their feet and been a little bit lazy with their guidance, but some of the guidance has indicated, well, look at the last period where they didn't need leave and calculate their hourly rate from that to use it for that. But it, again, depends upon their wage, what's in their offer letter, if any, and having that all information in front of you and looking and then connecting with your attorney or in-house counsel, whatever you may have, to confirm. But that's generally what the guidance has said that the department has issued to date.
Yeah,
And
so this is where we would want to do an amendment to their employment contract. Not necessarily starting a new contract with that employee, but do an attachment to it that explains this stuff for them as those certain special employees are affected.
I'm not sure I would do that. Again,
Okay.
that's getting to a very specific scenario that, again, connect with your attorney. I would. So when you get into amending a contract, an employment contract, that dives into a whole other mess of issues. So the biggest one, and the also the one from the most recent legislative session, is the legislator banned non-competes. So if you have a
Right.
non-compete in an employment agreement, and then you go back an amendment, or you go back and do a new employment agreement, well, that non-compete may not be enforceable anymore. So before diving in and changing a bunch of things, connect with your attorney on it first, because it can open up a whole can of worms.
All right.
Okay, so there's a variety of other requirements which we haven't discussed. I've written a ton of blogs on them. If you'd like, I can send some. Just please email me. But there's a whole host of other things that are equally as important to the main highlights and the main points we discussed already today. So, number one, retaliation is prohibited. So be extremely cautious when terminating an employee who has used leave, because retaliation, similar to the Minnesota Human Rights Act, similar to Title VII, similar to many of those different employment laws, there can be repercussions for terminating these employees. So paying benefits, employers must maintain coverage under group policies or healthcare plans. However, the employee must continue to pay their share of the cost and the such benefits. So as stated up here, nothing prevents employers from providing more generous policies. In fact, I'd probably say almost a majority of employers I've been dealing with now actually implement policies that are more generous in some way. For example, they're front loading you 100 hours rather than 80, or allowing you to accrue at a higher rate and faster than what the law requires. So you're absolutely entitled to do that. The department is not going to kick down your door saying, hey, why did you give these employees more of a benefit than they're entitled to? That's not what they're there for. Employers are allowed to implement a policy that allows employees to donate accrued or banked leave to other employees. A lot of employers just do that generally or with other leave policies. As we discussed earlier, the law doesn't require us to pay out employees unless it's in our handbook, and that's a benefit we provide to employees. There's some scenarios where, and this is particularly important for employers who employ like a seasonal workforce. If you terminate an employee and then they rejoin, how does that work? And it's different scenarios depending upon whether you're operating under a front-loaded or accrued model. And there's also a time limitation of 180 days associated with that. So depending on how you operate, there may be a situation where an employee will rejoin you, a month after being terminated and still have banked leave. And then finally, well, before we get to this last piece, which is regarding remedies, often employers don't see that the increment of hour used must be in the smallest increment of time, provided that that increment of time is not more than 4 hours. So if we're providing leave and our payroll system tracks time down to, a minute or down to 10 minutes, there's an argument under the law as it's drafted currently that, well, we may have to provide leave on that tiny of a scale. Now we're waiting for more guidance on it, and we expect some guidance to be issued on it, because that seems unreasonable to allow an employee to get leave for 4 minutes for letting their dog out or something of that nature. Even though letting their dog out would not be an ESST qualifying reason, but just for the sake of the argument. So keep a heads up. I'm trying as much as possible to stay on top of the FAQs. So if you're not signed up to our email list on Ogletree to receive our blogs, consider signing up, because then it'll automatically send you a blog anytime I decide I want to chat about the ESST law, which lately has been often. So consider signing up. Okay, so finally, there's the remedies. So it's the big so what question. What happens if I don't comply with this? Well, there are significant remedies. The commissioner can investigate. They can ask for documentation. Commissioner can potentially assess fines up to $10,000 per violation and per employee. They can be significant. And then there's also a private remedy. So private individuals who are wronged or not given their rights may potentially sue. So if you don't give your employees the allotted hours, they can implement a private cause of action, which that can be costly to defend and costly to settle or resolve. All right, next slide. So takeaways. So there's a whole bunch which we just all went over, but here are some of the big ones. So the department has issued template notices, template policies. You can either email me or go to the department and find those and see what we have to post, and that they'd be posted in the same place that you post all your other workplace posters. I assume there's a sea of workplace posters. You'll be posting it. So consider looking at that, because that will be important, and it is a requirement of the statute, or the statutes rather. Another big issue is review your pay stubs. I've seen a ton of employers whose pay stubs are not compliant still with the Wage Theft Act, which is legislation that went into effect several years ago, which says here's all the different categories we need to include in our pay stubs. In fact, I just chatted with an employer just the other day that didn't have 3 different categories of approximately 10 not listed on the pay stub. That can create headache, that can create issues. So review your pay stub, review the law to ensure you have everything that's required to be there. Consider updating your handbook, especially after this last legislative session, which has impacted numerous different laws. Like I mentioned, I've written about these. I'm happy to send you some blogs. but it's impacted pregnancy bills, parenting bills, or laws rather, the non-compete legislation, wage disclosure. There's a whole ton of different laws that were all passed this last session that impact employers. So get up to speed on those, make sure the handbook is ready, especially if you're a drug testing employer. As you know, marijuana was just legalized, and so that creates an additional headache if we drug test. As Susie would say, ensure your payroll systems are updated and accurate. We don't want employees to either think they have more hours than they do or do not. So ensure that everything is being tracked appropriately. And always make sure that we're complying with in good faith with the black letter law. That's incredibly important with these laws, especially in Minnesota, which can be particularly problematic for employers.
I would also say if you're a small business, make sure you include more than just you in understanding what these laws are, to make sure that your team, whether you have frontline managers or supervisors overseeing people, it is important that they understand some of this stuff too, and that there's some training done around this, because it's a lot to undertake for one person, and it usually takes more than one person to kind of manage it. If you have a team of people overseeing individuals and stuff, if there's 2 employees, I get it. That's a little different. But if you do have managers and supervisors, it would behoove you to put together or have, I can come in and support Colin, different things like that, right? Where we can come in and say, like, here's some of the new laws, and here's what you guys need to understand based on how it's wrote in your handbook or things like that.
So questions, we've ran through some of these, so I'll try to pick and choose so we can use our time as judiciously as possible here. All right, so what if the employee lives in Wisconsin and works part-time from home with a Minnesota-based employer? Well, if they're working in Wisconsin and haven't met any of the requirements of working in Minnesota, they're not going to accrue paid leave. Of course, that gets into a complicated issue of, well, what if I amend my policies to comply with it, and I have a PTO policy that applies to an employee in Wisconsin? That gets into a little hazier of a situation, but just strictly speaking about the black letter law, if an employee lives in Wisconsin and works for a Minnesota-based employer, they're not entitled to Minnesota ESST unless they meet those strict conditions.
So put it in layman's terms, it's where are their feet at the time of working?
Correct.
Is it in Minnesota?
Correct. What if the company already has PTO that the employees can use for sick time? Well, that's great. Like I mentioned, as long it doesn't matter, the law doesn't discriminate on what the policy is called. The policy just must comply with the bare minimum requirements of the new law. So if you have a PTO policy that is meant to comply with the sick and safe time policy, that is permissible. Many employers are doing it that way. They don't have their own specific ESST policy. They just incorporate the ESST policy into their PTO policy and ensure that it meets the minimum requirements. What if the employees only work in the summer? Well, again, this is going to apply to seasonal employees, temporary employees, as long as they're employees. So yes, it's going to apply to employees who only work in the summer, as long as they work at least 80 hours and they accrue enough leave. So that'll be important. And again, that goes to the point of, well, what if I have, on-off employees? Well, then that may potentially further increase your compliance, because if an employee rejoins, they may still be entitled to that leave. And that still, same thing applies to seasonal as the next question. What if the employee only works from home? That's going to really depend upon the employee's job, the hours they're working. Most likely, I would assume that's an exempt employee, although not always, but it'll apply with an employee who works from home, as long as their home is based in Minnesota and they meet those other restrictions. I think there was a few others I wanted to touch in on the second one. Okay. What if the employee only works 2 weeks and quits? Well, they would work the 80 hours, but they would have only accrued, well, I guess this question depends upon how much they're working per week. They would have, if they worked 40 hours, then they would have worked the 80 hours that is required to be an eligible employee. And then they would have probably accrued, I didn't go to law school for math, but again, 1 hour for every 30, they get 1 hour VSST for every 30 hours work. So that'll be, 2 point something. If they ask to use it, or if they quit, I mean, they're certainly not entitled to that 2 hours unless you have a policy saying employees who quit are entitled to it. Do I need to pay sick leave if the employee quits or is fired? That gets into my question, my response just a second ago. So nothing requires us to pay an employee who is terminated or resigns, unless, of course, that is something in our policies. Again, it's a matter of contract between the employee and the employer. Do I need an employee handbook? Whew, boy, that's a loaded one. Erica, what do you think?
Yes, please. I mean, it's important because there's a lot of laws. I mean, going through just helping clients currently with updates from what they had. There's a lot of laws that are required if you have more than yourself. And also note that there's a difference between handbooks and policies. We can write separate policies for day-to-day things too, as an HR team, but a handbook is definitely needed because of all the laws and requirements. A perfect example is this, right? You have to tell employees what they're allowed to have, right? And what we're required to tell them that. And this is a way of delivering that from point A to point B, so to say, right? From our hands to the employee's hands. So.
Right.
Yeah,
And even going into what is overtime, that needs to be written in your handbook because it's different for different employers. It's not a state regulated. Correct me if I'm wrong, Colin.
No. And I completely echo everything that was said. I think a handbook is critical, especially these days. And it's really helps not only set expectations for employees, but helps employers from a risk standpoint. I can't tell you how many lawsuits I've litigated in which the handbook becomes implicated and involved. And did we comply with the handbook? Did we not comply with the handbook? And with how easy it is to get a handbook these days, I mean, there's numerous folks helping draft them. I draft them on a regular basis. I mean, Ogletree even has a handbook builder now where you click a bunch of buttons and out pops a handbook that is specific to you. And so with how many resources are available at the hands of you these days, I think a handbook is critical. And that gets into how do I make an employee handbook? Well, you can draft one yourself. There's a lot of templates online, although I don't trust those. There's folks like Erica helping. There's folks like me who help. I caution everybody that wherever you get your handbook, and as good as you think it is, run it by a lawyer quick. I can't tell you how many handbooks I've had folks create themselves and then come to me and say, hey, can you look at this? And it's a quick, easy thing for me to run through and say, hey, here's some question marks and some issues I'd correct. So there's the making it and then confirming we're good to go on that.
And I think that I spoke to this a little bit earlier. I've worked with clients where they've done some of the, so to say, drag and drop, build your own, it's a great place to start. There's nothing wrong with starting there. And just to preface it, I tell everyone that they still have to have handbooks, even if I work on them, go through legal. I just hope that at that point, it's going to save time because I know about this enough to know to put things in there and make sure we're doing it. The biggest thing is when people build handbooks, they want to put everything in the handbook, everything possible. And then all of a sudden, when you actually sit down and read it and you go, Are we actually doing that? Oh, wait, no, we don't do that. Okay. Well, then it shouldn't be in your handbook, because as much as things not in your handbook can get you in trouble, having too much sometimes in your handbook or worded incorrectly could also get you in trouble. So it's important. I jokingly have told some of my clients, I'm kind of that independent third party, that I'm not there day to day. Let me take it and review it and identify some things. And it also allows them then to go back and kind of talk about it amongst themselves before we send it over to legal and say, okay, here's everything we've changed. So it is important to make sure that while all of you have, so to say, day jobs, right? You're responsible for a lot of stuff. This might not be your gig, right? Like this might not be where your world is, and that's okay. People like Colin and I will walk you through it potentially, or be able to sit down and ask questions, and the information will then come a little bit easier for you. So.
Okay, there's a question in the chats, and I'm going to kind of rephrase what's actually written there. So let's say a mover is in the semi truck driving through different states. So for Minnesota, we're only going to calculate the hours they're inside of Minnesota driving. But then if another state like South Dakota or Colorado have the same type of thing, then we need to calculate that differently also per their laws.
So let me try answering this so I'm not giving legal advice. So in Minnesota, like I mentioned, as long as you hit that 80-hour mark, that means you're an eligible employee. So if an employee is working in Minnesota for 80 hours, then they'll start accruing ESST. It doesn't matter if they're, only accruing ESST leave sporadically or working sometimes in Minnesota or out. As long as they hit that 80-hour and then they work additional time after that, they'll start accruing ESST. Now, the other laws, that really depends on the state. Each state has different ESST laws. While a lot of them are called earned sick and safe time or earned sick and safe leave, each are markedly different. I was just advising an employer who has numerous locations all over the US, and in a number of their states, they have different ESST laws. And it becomes a tricky question on, well, how do we comply with all of these in a way that makes sense for us as an employer, where we're not, giving a ton of leave or having separate addenda or so on and so forth. So that's about as good as I can do. If you have more specific questions on that, I'm happy to dig into it further and chat with you more.
Yeah, and that's one of the reasons why Colin is here. His company is in multiple states, so they have the resources to help compile something like that, because in this day and age, we do have that multi-state easily, like a football player. Where are they working? They work in every single state, So we're starting to get that way around here. Okay, we are at 2:00, so we should probably wrap up quick. If there's any other questions, throw them in the chat. And I just want to make sure we grab this slideshow or this slide, which is a newly added from today. So, and Colin's probably going, wait a minute, I haven't read this.
I have not had the privilege yet, but
But
okay.
Alex, while he's reading that, if you have a question, and I know your name's probably not Alex, but what do we got here?
Oh yeah. So can you force an employee, or can employees say they want or do not want to use hours as unpaid? Well, this is actually a pretty easy one. We don't know yet. There's nothing in the law about it, and we're still waiting for guidance on it. There's some hints in the Minnesota Department of Labor on, well, can I force them to use this? Well, really, what's only mentioned is, can we have them use leave concurrent with other leave? And the answer is yes. But whether or not they can take it unpaid or not paid, That's something we're still waiting for more guidance on. So stay tuned on that. And so question 2, combining PTO and sick and safe leave. So yeah, as I mentioned before, you can combine or make your PTO policy your ESST policy. Again, the law doesn't discriminate what you call it. How it works, you just have to meet the bare minimum requirements of the law in your policy in order to be compliant. That's an oversimplification, but that's generally the case.
And if anybody else has any comments or questions, you can just go ahead and unmic and ask. I
Hey
like to see
guys,
if we can get Colin to score.
thanks so much, first of all, for just giving this info. I have pages and pages and pages of notes that I'm going to have to go over. There was a question at the bottom of the last slide that I was actually pretty curious about. If an employee works, makes up the time that they were sick by either working on a weekend or they take another shift from someone else or something like that, how does that work? Are they still entitled to get paid for that time if they make up the hours elsewhere? How does that look?
Yeah, so that's another, and I hate to say this, that's another easy one. And it's because there's no guidance on that yet. It's not specifically stated in the law. Of course, as you know, the law is this broad piece that gets passed, then the department interprets what the legislature says, and then us lawyers try to decipher whatever the heck the department is thinking. And so unfortunately, we don't have any guidance on that. But again, the department is issuing FAQs. They're going to continue to do so through the end of the year. So stay on top of that. Again, if you haven't, if you're not signed up to our blogs, consider signing up. You'll see my face popping out FAQs every chance I can get, or updates on FAQs rather.
Yeah. And I'm going to use my company as an example. I have virtual people. They work on their own scheduling. No matter, they can work at 2:00 in the morning as long as the work's being done. I don't care. However, if they have that 40 hours a week, I'm not going to know that. They have to tell me that they were sick. So would it be good, and Erica, this is probably a better one for you to just chime in on that policy, that they have to write out they were sick and they were using these time. Like salary people, it's the same every single time. So you don't think about salary people turning in their hours. But if to use their sick time, they need to turn in those hours of sick.
Yes. The simple answer for you, yes. I'm going to give an answer like Colin. This one's really easy. Yes. Obviously, in today's, I say this day and age, people work all the time, whenever, wherever, right? And so there is that back and forth. I've had to sit some of my clients down that have salary employees and they're like, well, I just work when I work and I get my hours in and I do it. And I say, but they have a bunch of PTO that's not used, and that's not good for us either, right? So again, based on how our policy is written. So it's really important that we get into the habit of this is why it's important that your managers and your supervisors understand this law and why we need to take it seriously and why we need to make sure it's being tracked, because again, if you do get audited or something happens at some point in time, you need to be able to provide that. So if someone's sick, I also feel like there are moments and times where this gives people the ability to say, if you're sick, just be sick today. It's okay, right? And again, today's day and age with all of this, it kind of makes us feel like we're never really done. I think that there's a little bit of it's okay. Go be sick today then, and you'll come back tomorrow. But we'll track it that way versus you only working, instead of us paying you for 8 hours, you're going to work 2 hours here and work an hour there. They have the hours now, allow them to use it. And it also kind of forces them to a little bit, not forces them, but it makes them feel like they can go and take those hours.
Okay, wonderful. All right, we're almost 10 after 2, so we'll wrap it up. Reach out to any of us if you have questions. this video is going to be posted on my YouTube channel. And then go ahead and share that. You know, if you have other business friends that are like, oh, they're talking about this over the Christmas parties or whatever you're attending, go, hey, listen to this webinar. Go ahead and get it there. That's why we're recording. And it's for us, it's just helping you guys get the information that you need so that you're not paying penalties for not doing it correctly. So, all right. Thank you both, Colin and Erica, for doing this for me. It's greatly appreciated.